All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
Three topics I want to cover today. The first is that earlier this month, the U.S. Supreme Court accepted review of a case called Ames versus Ohio Department of Youth Services. And what the Supreme Court is going to consider in this case is how to resolve a split in the federal circuit courts on the standard that those courts apply in discrimination claims brought by majority group plaintiffs. So think of reverse discrimination claims, white individuals bringing race discrimination claims, males bringing gender or sex discrimination claims.
So, Bert, is that really reverse discrimination, or is it just discrimination in another way?
Well, I think that's what
not in how we normally think of it.
I think that's what the court's going to tackle, Phil. Typically, the courts have used what's called the McDonnell-Douglas test for evaluating discrimination claims under Title VII. That case goes all the way back to 1973. That test has some variations, but generally under that test, a plaintiff has to prove that they're a member of a protected class, that they were subjected to an adverse employment action, that the individual was qualified to perform the job in question, and that the employer treated the individual, treated similarly situated employees outside the protected class more favorably. Okay. And under that burden shifting method, if that or framework, if the plaintiff proves those four elements, the burden then shifts to the defendant to show a valid non-discriminatory reason for the adverse employment action. If the defendant makes that showing, the burden then shifts back to the plaintiff to establish that non-discriminatory reason is a pretext for discrimination. So that's generally the test, okay? In addition to those McDonnell-Douglas factors, there are many courts in reverse discrimination claims that have required the majority group plaintiff to show, quote, background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. Okay, so
wow, that sounds like a lot of loose words to me. Suspicion, unusual, yeah.
Yeah, and so what the court here is basically going to have to tackle here is that the federal circuits are deeply split on whether to apply this background circumstances test to majority group claims. And really, it adds an onerous burden that it makes that the plaintiff in this case is arguing that if the courts apply this onerous burden, the courts themselves are engaging in discrimination against the majority group plaintiffs. And so this ties into a case that we've talked about quite extensively on the show. The Supreme Court stated recently in that case of Muldrow versus the city of St. Louis that, quote, eliminating discrimination means eliminating all of it, end quote. And so what they're going to tackle here is, should there be this extra standard added? And that gets to your point, Phil. Is it just discrimination? Should there be an added standard when it's a member of a majority group that is accusing the employer of discrimination? And so my gut tells me on this one that the court's going to do away with that something more standard, but we'll have to see how that plays out.
Yeah. Well, we'll keep an eye on that one. That can change a lot of things depending on the ruling of that. So
it can, and I think it could really impact employers' DE&I efforts as well. So we're really going to have to keep an eye on that.
Yeah.
All right. Okay, so the next one I have
there, Mr. Lawyer on the clock.
Yeah, the next one I have for you here is this one relates to UPS, United Parcel Service, and they have filed a litigation in a federal court in Delaware, where they are telling the Delaware court they're seeking an emergency temporary restraining order and a preliminary injunction preventing OSHA from enforcing some warrants at two of its facilities in Delaware. And so I'm not citing the case, and I'm not going to get into the specific facts of the case, but one of the things we've talked about repeatedly on the show is what to do when the government comes knocking, whether it be OSHA, the Department of Labor, showing up for a wage and hour audit, or anything about having to anything, the EEOC shows up, any of those agencies showing up at your door and sort of flashing their badges around and sort of demanding to come into the employer's premises. And I've always said, treat the governmental official politely, take them into a conference room, don't walk them through the facility, and get your legal counsel on the phone, because you're entitled to representation during these inspections. The other thing I've always said, though, is that when somebody shows up with a warrant, that's a different ballgame. That means they've already gone to court and the court has ordered an inspection, and there is an ability to redress that legally through an emergency filing with the courts, through a temporary restraining order or a preliminary injunction. But just know that when they show up, unless they have that warrant and they are authorized by a court to access your premises, then generally you have the right to have them come back at a time that's mutually convenient for you, your legal counsel. And just remember, employers have rights too. All right. Yep. And then the last one I wanted to talk about, Phil, I think you'll like this one. I don't know. Something tells me you'll like this. There's a case that
it always worries me when you kick it off with, I'm going to like this one. Yeah.
Well, we'll see here. So there's a case that was decided in the last couple of days out of Washington federal court. And what this court was doing was it was reviewing the award of an arbitration board that was comprised of union members and company members of Alaska Airlines. And what they were deciding was, should a mechanic be reinstated after he was fired following a positive test for marijuana? And so in this particular case, that arbitration board concluded that the individual should be reinstated even though he tested positive for marijuana. And the reason they decided this was because the employee admitted that he accidentally consumed marijuana at a friend's barbecue the day before on a Sunday. And so that's why he had a positive test for marijuana.
That sounds to me like the stories I used to hear. I don't smoke marijuana. I was just in the car. Somebody else was smoking it. And I just happened to be in the car. It wasn't me.
Yep, that's exactly right. Well, Phil, you and I have spent a lot of time. We've had Missouri State Master Sergeant, patrolman or highway patrol member, Tyler Jenkins. We've done a lot of training for your members, for my clients, on indicia of impairment. And the standard under most of these states' laws is that whether somebody tests positive for marijuana or not, that's not necessarily dispositive of the issue. It doesn't mean that the person is under the influence of marijuana. Because the way marijuana metabolizes in the system, you could have consumed it quite a while ago. It's still in your system, but you are not necessarily impaired. And those states' laws say that you cannot be impaired at work. And I think in this case, things might have been a little bit different if the employer could have shown that the employee was actually impaired at work. The employee got caught on a random drug test, and there was no evidence that the employee was actually impaired at work. And so I think that gets back to all of the training that we've done with your members, with our clients, that people really do need to be educated on these indicia of impairment in order to make a discharge stick for somebody who gets caught on a positive marijuana test. You need something more.
I just have a few questions. I still don't know why you think I would like this one. However, I do have some questions for our audience. First is, so the person was tested positive on a random test. There was no suspicion of impairment. And the person was discharged and then reinstated.
That is correct.
Right. So now the questions haven't come in on the text line. I do have some other ones here, but that question I would assume, so does that mean I should be doing indicia of impairment when I do my random, or what's the purpose of the random? Can I still discharge people? And I think that's the space that we're in today, where it's very, very difficult to make those types of policies stick when we have a mixed match of, marijuana is legal, medical marijuana is legal, It's not legal. We're in a kind of no man's land here.
We are, and I think that's where it really becomes important because under the whether it's recreational or medicinal, the individual still does not have the right to be under the influence at work, and the only true way to make that determination, I think, is those indicia of impairment, those indicators of impairment combined with the tests. My understanding is that there is a relatively new resource out there that may help measure impairment by marijuana, a technical device, but it has not been tested in court yet to see if it would pass muster with a judge.
Yeah, well, that will be a golden ticket once that comes out.
Yes.
But until then, should you need some help, Bert and I are always happy to reach out and help. This is an area that we've done a lot of training on to help employers determine that, up to including, Bert, we like to bring impaired people to the program and do testing on someone who is impaired. I want to go to the chat line here real quick, Bert. Our long time from the beginning listener, and he likes to interact, Dave Forsey, is made a comment that his favorite episode was when you had to provide legal representation for your Huskies because they got out in your neighborhood, and I think you had a tracking collar and had some problems. This was one day when your Huskies took a hike.
Yeah, but Huskies took a hike and ended up about a mile away after about 2 minutes, and they proceeded to gosh, it's still hard to talk about, massacre somebody's chickens in their neighborhood. And yes, so that was a tense situation. Luckily, the neighbor ended up being very gracious about it. And my dogs have not killed anybody's chickens in a couple years now.
Yeah, you just bring them over some rotisserie replacement chickens. It's fine. Yeah, yeah.
Thanks for that reminder, Dave.
Hey. But that just goes to show you people are listening to the strangest things that we talk about. I don't know about you, Bert, but I just want to show episode 300. I have 300 little donut holes here that were brought in by Nick and the team, Fred over there at Feature Group. You got your little care package delivered this morning.
I did, Phil. I got bagels and cream cheese. I think that says something about the health that you and I follow.
Well, hey, you just keep looking at that Spartan picture, episode 300, right? That's what we have in our mind, Bert.
Exactly.
All right. Anything else from Lawyer on the Clock?
No, I think we've got it.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.